Hello, so today we'll be learning about the essential elements of a lease. Now, the first element is the certainty of parties. And this means that the parties to a lease must be certain as ascertainable. So, of course, in a lease transaction, you have the lessor and the lessee. So there must be persons who are not of any legal disability, must be juristic persons who can enter into that transaction. The next element we have is the certainty of property. So the property in question that is subject matter of the lease must be sufficiently described and be identifiable as well. The third element we have is proper form. With proper form, what this means is that the lease must be created the right way. Of course, you know that when we have a short-term lease, what we call a tenancy, all right, which is a lease for a term not exceeding 3 years, or less than 3 years. What would suffice would be a tenancy agreement, whereas for any lease for a term of 3 years or more, what you would require is a deed of lease. Now, of course, if in a question, and of course, in most questions, the property you'll be dealing with will be property that has been registered, all right? So property for which the governor's consent has been granted. You would call it a deed of sublease, not a deed of lease. Why? Because the grant of consent by the governor, we take that to be the original lease. Because remember, under the Land Use Act, all land is vested in the governor, and he grants rights for persons to use and enjoy those properties. So every person who is in a property for which governor's consent has been granted has an original grant from the governor. And so in that case, if a person is now granting a term to another person, we look at it technically as a sublease. So it will be called a deed of sublease and not a deed of lease. Now, the next element we have is exclusive possession. Now, what that means is that the lessor must grant the lessee exclusive use of the property. All right, the tenant or the lessee during the term of the lease would have the right to exclude every other person from the property, including the lessor himself. All right, of course, the lessor would reserve the right to come upon the premises in order to make inspection and repair, subject to reasonable notice being given to the lessee or to the tenant. Of course, because the lessor wants to protect his reversionary interest, and that's why he would like to come on from time to time to repair or to inspect the property, but he must give notice first. Okay, and the last element we have is the certainty of term. This is very important. All right, so a lease must be granted for a term that is certain and ascertainable. All right, and in that sense, it means it must have a certain commencement date and a certain expiry date. All right, because if it doesn't, then it won't be certain. All right, you can't just give me a lease and say, I'm leaving the property from today till whenever I want. No, that won't be certain. Now, of course, in certain scenarios, you may not have a certain date for expiration. However, it may be made subject to the fulfillment of a condition precedent. I'll take that back. You may not have a certain date for commencement. All right, the lease may be made subject to the fulfillment of a condition precedent. Now, as long as there's a certain expiration date, and that lease would still be valid. For instance, if I grant you a 5-year lease to commence on the date of the resumption of the Nigerian Law School. Now, that means that once the Nigerian Law School resumes, that lease becomes certain and ascertainable. So it will still satisfy the requirement for certainty of term. So those are the 5 elements of a valid lease. And I hope you've enjoyed learning again today.